the Road Traffic Act. We're at section 22. Provisions as to physical fitness of applicant for permit or driver's license. I'm increasing the zoom on this thing. The authority may impose conditions on an applicant for the issue of a permit or driver's license, including a requirement for ophthalmic and auditory or other medical examination. So in that case, you might require visual and hearing test, right? An eye test and hearing test if they suspect that you have a hearing difficulty or visual difficulty. All right, that's subsection 1. Subsection 2, where an applicant for a permit or driver's license has a prescribed disease or physical disability, the authority may grant to the applicant a license limited to the driving of a motor vehicle, modified so as to allow the applicant to operate the motor vehicle despite his disability, if the authority is satisfied that the applicant is fit to drive the motor vehicle. 3. Where the authority certifies that the testing of the applicant proves his fitness and ability to drive a motor vehicle of a particular construction or design only, the authority shall not refuse to grant a driver's license pursuant to the provision of section 25, subsection 1, or we're just at section 22. Section 25, subsection 1. However, it shall be a condition of the license that the licensee is only permitted to drive a motor vehicle of the particular construction or design. Subsection 4. Where, on considering an application for a driver's license, the authority ascertains that a driver's license was previously issued to the applicant after passing the test mentioned in subsection 3, a further test shall not be required unless, based on the declaration as to physical fitness made by the applicant, or from information received by the authority, it appears that the prescribed disease or physical disability has become more acute, or the applicant has another prescribed disease or physical disability not disclosed on the previous occasion. All right. Subsection 5. The authority may revoke a permit or driver's license in the circumstances set out in subsection 6. The circumstances are: A, where it appears to the authority that there is reason to believe that the holder of a driver's license has a prescribed disease or physical disability likely to cause the driving by him of a motor vehicle to be a source of danger to the public. And B, on inquiry into the matter, the authority is satisfied that the license holder has a prescribed disease or physical disability. Subsection 7. Before revoking a permit or driver's license under subsection 5, the authority shall: A, certify in the prescribed form that it is satisfied that the license holder has a prescribed disease or physical disability And B, give notice in writing to the holder of the driver's license or its intention to revoke the driver's license, stating the reason for the proposed revocation. All right. So if they find out that you have some type of sickness that would impede your ability to drive, they can revoke your license. Subsection 8. The holder of the permit to driver's license that is proposed to be revoked under subsection 7, part B, that's this part, may, except in the case of a prescribed disease or physical disability, make a request in writing to be subjected to the prescribed tests as to his fitness or ability to drive a motor vehicle. And if he passes the prescribed test, the permit or driver's license shall not be revoked. Subsection 9. The authority may, after considering a request under subsection 8 and the circumstances surrounding the revocation, issue a new permit or driver's license. Subsection 10. Where a permit or driver's license is revoked under this section, the holder shall return the permit or driver's license forthwith to the authority. So if they revoke your license, you must submit it as soon as possible. Forthwith, right? Means immediately. Subsection 11. A person who fails to return a permit or driver's license that has been revoked under this section to the authority commits an offense.